Parental separation can be tough, and the idea of having to navigate a co-parenting relationship with someone that you don't like can be even more overwhelming. But you don't have to navigate this on your own. We welcome you to the White Table discussion, where we bring to you real life stories with real people discussing subjects, stories, most importantly, also the heartfelt messages of parents and children. Most important, every week we will have professionals to give you advice and guidance, but also bring you some of those other people maybe like yourself that have already been where you are now, to help to guide and give you some advice at that level of understanding from the emotional home. Most important, if you're here to hang around and hear us a little bit more, every week we will be bringing you stories. All you need to do is hit that subscribe button so that we can do more for you and helping to build this community whilst we've been running now in our 5th year of the White Table Discussion Project. My name's Jeannie. I'm your host and the founder of Parenting Together Apart for Parents Not Together. I look forward to seeing you inside. So, hi everyone. My name's Jeannie from Parenting Together Apart. Welcome, Kaj, to the White Table discussion. And
Thanks,
Kaj
Jenny.
is a family lawyer based in Melbourne. And today we're going to talk about whether to. I think most common question we get is, when is the deciding factor to go to court, but also when do you settle? Like, the balance between the two. So it'd be great to get a perspective from, a legal perspective, I guess, Kaj, on what that looks like.
Sure. Um, so, you've got a legal dispute, whether it's parenting, whether it could be anything, but, you go see a lawyer and subject to many factors, the lawyers tend to suggest, okay, let's mediate this, let's negotiate a resolution, an outcome. And I think it's important. One important point in whether determining whether it's appropriate to negotiate is to see if the parties are still communicating. Are they prepared to reach a compromise or not? In many cases, they can't, especially if there's family violence issues, mental health issues. But uh, sometimes when parties come to me, or usually they have already opened up lines of communication, sometimes it's heated, doesn't work out. Other times they come to me saying, "Look, we've already had a chat. This is round about what we want. Can you please help us, get to that end point where we can finally um, formalize what we've agreed to, which is legally binding." So, um, I think whether to the decision to litigate versus settle, will probably one point is, whether you've got that, whether those communication lines are there, whether there's a communication and parties are open to a compromise. Um, Subject to obviously not being any sort of safety issues as family violence or child abuse, that sort of stuff. But um, so that's one major thing I look at when determining whether parties should open up lines of communication to try and negotiate, or go or consider going straight to litigation.
So what happens when we have, because obviously, as you know, we get a lot of our parenting matters sort of a point of agreement, but then there's a halt because there's a dispute over, what the expectation is on the financial component. And so, many parents seem to get very confused about, for example, if it's going to be, a difference of a 60-40 or 50-50, 70-30, whatever that may look like on a financial split. But in dollar value, it may not be a lot. In fact, it may be the same amount that they're going to have to use that extra dollars to fight out to get the initial outcome. So what
Mm.
would be like your advice to the client? What
Sure.
would that look like?
I think I think it's critical for lawyers to advise their clients about the cost benefit, in all given circumstances, especially if they're at a juncture where they're considering going to court versus compromising. So if they want an extra 5% or an extra 10%, but the pool is such that um, you do a cost benefit analysis and it's going to cost you, about that or maybe more or maybe a little bit less to run the matter to court, initiate proceedings, and engage in the first few sort of steps, then I think it's prudent that other options be considered rather than going straight to court. Can they reach a compromise somewhere in between, or what I'm trying to say is continue lines of negotiation. If it appears that the costs to go to court at that juncture will far exceed the benefit. So I think a cost benefit analysis should always be, I think, at the forefront of a lawyer's mind, and they should inform their client of um, the benefit of negotiating versus going to court, which one would be the better of the two, depending on the amount of costs they'll spend versus what they could expect to incur, depending on which option they wish to choose. So, yeah, always cost benefit analysis, always. It's like the golden rule for me, because I think a lot of the disputes are about what it's going to cost, and I'm highly transparent in relation to what it will cost or could cost clients if they go to court. Tomorrow they can't, so tomorrow they're not in the unknown, or I didn't know it was going to cost me this much. So they're fully aware, and costs are disclosed, so they can make an informed decision, before taking that step and incurring those costs. So I think it's critical for any lawyer to do a cost benefit analysis for their client's benefit.
Absolutely. So, on the event that a person is quite adamant that, they're determined, they have their own reality of what they believe is they're entitled to, how do you combat that? Like, because we see this often where just one party may be just so adamant that they're entitled to X amount of dollars, or long-term care, being financially pulled by the other party. Like, how do you, like, where does the line stop where you need to continue forward with, that instruction by that client? But from experience, once it starts the process, is that something that definitely can be halted, let's say with the court mediators? Like, what would be your view on that?
Yeah. Look, everyone's entitled to their views, their perspectives on where they stand, what they should receive, what they should get, and sometimes it's in sync with the law. Sometimes it's um, well outside of the range. And you're entitled to that view. And look, the law is the law. The law has its own system, and what it regards as or what entitles parties to, whether it be a financial division or parenting matters, what's in the best interest of the child. But each each person has their own views, based on their life experiences, what they've been told, what they've read, what they've researched. Ultimately, as a legal practitioner, I need to give advice to clients based on the law, based on the facts. And look, if they still say, look, I wish to, agitate what I believe to be my entitlements, then I will support them through that. Okay. So long as they know that this is what the law says and this is what they could expect to achieve, which may be different to what they want, I will support them through that process. But ultimately, if they need to understand that if we go to court or if we agitate a particular position and um, the result is the same or similar to what I advised them initially, then hopefully they'll understand that that's I was very clear up front, transparent with them, and but ultimately, they've got the right to agitate their position, irrespective of the law. I'll support them through that. And I think that's all I can do. I mean, I understand completely. People, the law is the law, but people have their views based on their life experiences, what they've been informed. I will give them a full and frank sort of an outline of, what price they could pay if they do proceed down this track, costs, credibility, the time, the energy that they'll invest by pushing their position, which might be against my advice in the law. But again, if their ultimate decision is no, no, Kaj, I want to push forward, I want to, then so be it. Okay, that's okay. I'll support you through that.
So we talk about the preliminary advice where, a client will go to a lawyer and, a lawyer obviously can provide advice based in that moment, and as you said earlier, in the first few stages of what may look like, uh, what may happen if they litigate. But many times from what we see, our common theme we see is parents still seem to be so stuck on, but the lawyer said conversation, and not quite realizing that the variables around that outside the early advice is also the channeling of what the other party's going to, also how they're going to respond. So how do you sort of guide that? How do we guide clients where they're now feeling like they're being surprised by changes in the initial advice?
Yeah. Um, there's there can be a difference between the initial advice and subsequent advice that a lawyer gives. Initially, the information we receive might differ from the information we might subsequently gain from the client themselves, from the other party. So the initial advice could be, this is what you could achieve. Later, it could be something else because the change could be so great that which renders the previous advice invalid, essentially. So what I try to say to the clients, look, this is what the initial information I had before me, and the initial information that I had before me was the advice I gave was based on the initial information. We've come a long way since then. You've given me more information. The other side have contacted me. They've given me information. Therefore, I have to reassess, reevaluate what could be, what you could achieve, what your entitlements are. Um, Here's the advice. Uh, and it happens a lot. What the initial information I receive versus what I receive as the retainer continues, as the matter continues on. The initial advice has to be reevaluated, changed. So yeah, um, and I try to explain to clients, look, this is why. Um, the information, I've got more information. Hopefully they'll appreciate that. I've got a better understanding of your matter. So I've got to look at all the variables. There was, the information I initially had, brief. Now I've got a more holistic view. So the advice has to be moderated. Yeah.
Changes currently, which I know we're not going to talk a lot today because we want to do another special podcast on that, but the current changes, especially around the new coercion control laws and especially around the increased payments for victims for DV. There are mixed messages out there. There's mixed conversations. We've also seen ourselves where, people have been waiting on these changes and then actioning either orders or protection orders or actioning applications. How do you navigate all that right now? Like, we're sort of in a time where these changes are shifting the dynamic of the way people are approaching
Mhm.
their intention of the court, their purpose. So how do you navigate? I know how we navigate it from our end, but on a family lawyer's perspective, how does that get navigated?
Um, so
There's two
Um,
sides, isn't there? There's the and again, we need to not dismiss victims of domestic violence, but we've got, and I think where I'm going with this, we've got those where have just been sitting on applications that have just waited for this change, and then they're going full ball. So I want to talk about that dynamic, and then also for the parents out there that are now faced as a direct consequence of those particular parents that have waited to submit applications where it may be more benefit for them.
um, Look, I think so. You're referring to property divisions and
Yeah, I
the
think if we're
change in
looking at
law.
property division, the financials, I mean, obviously parenting is a
Yeah.
factor as well. But,
Mhm.
we're seeing often where either people are, they're holding out, all the intervention orders are just suddenly going out there, and on the basis of promoting the idea all of a sudden that DV is a factor. So
Yeah.
there's the cracks in between where these services are really, these new service products are provided for genuine matters, but we're also seeing those that are getting in between those cracks. And
Yeah. I think it'll be interesting. I mean, DV, it's as you said, it's a recent inclusion, especially for property divisions. A consideration. It was in there was case law about it. Now it's been codified, but it'll be interesting how the court deals with it. Will they look at proven facts of DV, or will they look at just allegations and previously with parenting matters, if there's an intervention order, even consent without admissions, it's considered, something that the courts need to take into account in determining, future parenting arrangements for children. With property divisions, it will be interesting whether, an allegation of consent without admission to an intervention order is sufficient to say, well, you've consented to an order without admissions, but that's considered an admission of domestic violence. It'll be interesting to see whether that's the position the court adopts, or will it be, well, no, there needs to be some kind of a finding of fact. So, for example, that you did commit family violence, not a consent without admission basis. So it'll be an interesting, I think, period now, how the courts consider applying the new law. But uh, and the other interesting thing will be, I mean, what adjustment, what adjustments will the lawyers, the mediators, the courts will consider for domestic violence? 5%, 2%, 3%, 10%. How will they quantify? So until there's no rules about that. I mean,
no,
with any property division, I mean, I could come to a different answer to you, given the same facts, and that's all I say to my clients. It's not a precise science. It's not a fixed science. I mean, I could say you're entitled to 60%, maybe 5% extra for domestic violence, but someone else could say, no, you're entitled to 75, inclusive of a 5% or 10% for domestic violence. So um, it's already sort of pretty broad brush, and it's not a precise science. So how will they deal with it? How will we navigate it? Well, we just have to be creative, and we just have to be uh, as I said, creative and colourful about it as much as possible. Noting that there are genuine domestic violence victims, and they should be entitled to a little bit of extra as part of the division or an adjustment. But because it's never been a precise science, it'll be difficult to pinpoint it, to a particular sort of a set of rules, or calculations. So, but yeah, we'll see. We'll see. See, Jenny. I'll keep you updated.
well, I think it's a conversation like that we're going to be definitely having in about 6 months' time, because the
Mm.
case studies will show itself, won't it? That the market's going to dictate to us how this actually gets determined. And I guess from
90% of 90% of cases, maybe more. Domestic violence is a feature, so it will
yes,
be raised, it will be
yes.
discussed. um, and it will be factored in to negotiations. And it might be, you
The
might find
figure.
that, sorry?
It's a high figure when we're talking about,
Yeah,
as you put it, 90% is like, damn, like that. That's a lot. And then, what's the figure that we really, like from our end, the toughest gig I think for us is seeing, victims that still won't come forward, like people that are seriously in a very
yeah,
unsafe situation, are so afraid to come forward. And yet we've got figures in percentages so high where the interpretation of what that situation looked like during the time of the marriage, and it's definitely leaning, it's gendered, let's not pull any punches here. It's definitely where it's leaning, for the women as opposed for the men. But how are we managing that? But then also, if you're a father out there and you've been now faced with allegations of domestic violence, and you're in the interim of working out both children matters and property matters, how does that get navigated? Like, how's that component become, you know, what's the approach? So for the fathers that you've had to represent or are currently, how does that get sorted in the web, and not to
yeah.
suggest that it hasn't happened or not, but the variables around DV is just so grand. How are we navigating through those shadows?
Yeah, look, I look at other factors such as, okay, I get to the bottom of it. Okay, if DV is a factor, okay, what's the impact? Um, what's the difference? And I explain to the clients, look, this is how it will impact your case. You know, and then I ask them, whether, and I give them a bit of is it worth sort of resisting? Is it worth arguing back? What's the benefit? And we go back to the cost benefit analysis. We work out, whether it's worth objecting, whether it be in a parenting matter or whether it be in a financial matter. Um, there are just so many variables. I guess I can't really uh, sort of pigeonhole it to certain facts, but there's so many variables. But I tend to assess whether to help them navigate the impact of it and how it could impact their entitlements, and is it worth objecting to, is it worth responding to. But usually it is, generally it is, and it comes more down to how they feel about it more than actual impact on their case. Especially in property matters, like, because they're running IVs are running parallel with financial matters and parenting matters, and it impacts the goodwill between the parties. It impacts their communication level, and I'm more of a diffuser. I'm more of a diffuser,
You
and
are.
yeah, I try to say, okay, yes, it's been made, but let's focus on the bigger issue. Let's focus on how can we maximize what you can get out of this? How can we maximize, because with children, you've got to co-parent with the other party. You don't want to inflame the situation. You want to provoke. You don't want to create more conflict than what it's worth. And everyone knows parental conflict is just the impact on the children is far-reaching. It's unaccessible, but so I think for me, it's just trying to diffuse the situation. If you want to navigate through, it's fine, but diffusing is the way to go. It's focusing on what's more important rather than those sort of allegations that are thrown in your face, and oh, she lied or he exaggerated this, or that's not what it was meant to be. But okay, that's fine. But what's the impact? Sure, we can go back with a equally as inflammatory and a hard response. But to what end? I tend to ask myself, what are you trying to achieve from this? Let's focus on the bigger picture here.
Yeah, the bigger
And
goal.
again,
Mm.
bigger goal, And again, that helps, clients hopefully appreciate that, it helps them determine whether we litigate or whether we try and continue negotiating what's important to try and settle the matter, saving cost, time, and energy, and hopefully try and preserve any goodwill you may still have, with your, with the other parent or the other party. But
How do we
it's complex.
how do
I
we
get it.
deal with the mental health arena now? How do we, you and I've had sort of quite a bit of discussions with some matters where mental health is definitely a factor and it's causing
Mm,
a lot of pain out there. It's perceptions are really tough, for a parent who has an idea or an ideal of what they believe should be, whether or not it runs with the technicality of the court system. It's what they believe. And how does a parent who has to navigate with that parent, like how are we, we've got our end, but how's that legal component? What is that doing? How does that, like, are we again defusing that situation? Especially if they have, appointed lawyers that are wanting to really take this all the way. How do you navigate that, Kaj?
um, I think it's important that uh, and we have discussed this before, but to be able to navigate a legal issue, you need to be in the right headspace. You need to be pretty lucid thinking. You got to make some decisions about the future of your life, especially when you've separated and there's entanglement, finances are entangled and there's kids. So, and then you're dealing with it, you're breaking up with someone who's, you might have been with them for 10, 15, 20 years and um, it gets very, very, very difficult, very hard for them to manage their own emotions. And I mean, personally, I say, look, you need to do counselling as soon as you go through a separation. You need counselling, and many people already have a counsellor. Many take up counselling during the course of the relationship, and they just continue on. But the courts, I'm finding that they order counselling a lot nowadays. Counselling is a almost a staple. Psychological assessments, psychiatric assessments, counselling is a something that's ordered quite frequently, and then really it's up to then the party to take that up and help themselves by doing counselling, taking care of their mental health. Now, I think that's the way the courts and the legal pathway deal with mental health issues. But there's other obviously there's heaps of different ways people can deal with their mental health beyond the law, whether it be meditation, whether it be healthy eating, exercise, all that sort of stuff. And I do say that to them. I ask people, often if I'm representing a particular, a religious person, I mean, I say to them, look, you want to connect with your God, connect with them. It will help you. It will help you deal with these issues. But in other areas, I say, or with other clients' situations, hey, look, you've got to take care of yourself. If you take care of yourself, you'll be able to make sound decisions about yourself, about your children, and about your future. So I think it's very important. I think as lawyers that we not only give legal advice on entitlements, but to ensure that your clients have got the capacity to be able to give those instructions to make decisions because I've had many situations where clients are confused or they just don't know. They just can't make a decision. I can't make the decision for them. They've got to make the decision. And sometimes what I find is that it's because they haven't taken care of themselves. You need to take care of yourself.
So
You
can
really
they,
do.
for some of them though, Kaj, some can't like some can't make those decisions on their own. Like we also see matters where they're just not, there are some serious diagnosis, their ability to navigate what they need to be doing next is definitely challenged. You can tell by the way that they are challenging, let's say, the mediators on what they want. Is it then
Mhm.
that having legal support throughout that process be suggested for them? Like, how do we sort of work with the parents that are just really having difficult times where they can't regulate? And what are the risks if it goes through the court process? Like, could this turn the opposite end for them, where possibly if the other side has knowledge of the mental health history, could that be then turned against them? Like, where are the layers of risk for them if it was to go through the court process itself?
Sure. I uh, um, I think that ultimately everyone's looking for a an outcome which is in their favor. They want to try and maximize their entitlements. Um, Sometimes they just don't know, sometimes, or they don't know where they stand. They don't know, what they could achieve. They may have read a few things. They may have done a bit of research, it's a bit of self-help to find out, where they are. But I think legal support at that, if they have then approached a mediator or try and negotiate with their ex, and they're putting forth a particular view and it's just not sitting right. It just doesn't sit with all. Then I think legal support is important. Um, and I think that you'd think hopefully once they get some legal advice on their views, their entitlements, they'll then moderate it, accordingly. Um, and I think you stated something about their mental health uh, obstructing their ability to
Absolutely, because
accept legal advice. Or
yeah, we get parents sometimes where we can actually see that they're just struggling to
Mm,
process, outside the ideals that they believe is right, and therefore
mm,
the challenges to be able to come to some agreement becomes a lot far greater. Now, one of the important steps I think is that parents, you need to understand that, like, even though many people say I don't want to go to a lawyer because I don't want to go to court because they associate going to a lawyer going to court, but we can also go to the right lawyer that can be there for support through
yes.
the arrangement for the children. That is okay as well. It doesn't mean that that lawyer will take you to court. It just means that they're legally supporting you. So you're protected and you have some clarity around what those legal implications are if you make it from decision A to decision B. I think that's something that's important for the
That's what I was
parents to
getting at.
know.
That's what I was
Yeah,
getting at.
yeah.
And hopefully then there's a void that's filled and they're then able to make a
Adding
decision about,
comfort,
yes, that's
isn't
right.
it?
So,
Yeah, yeah.
yeah. So
I
I think
think
legal
it's
support.
important. Because I think,
Mm,
the stigma about lawyers, which probably will, stick a little bit for a while yet, no different to car salesman, all respect to all the car salesmen out there because we need you. But my point there is that half the viewers have now shut down. But I guess the reason for this is because, having a lawyer at times can be helpful and not to be afraid to ask if you're not understanding. So, there's a collaboration, like we have that collaboration with yourself and other lawyers where we're able to work together to ensure that the parent is always clear about those steps, especially where there's some fragility around mental health and what that looks like. It then provides a just a, another softer foundation for them to know that, at least there's another pair of eyes with that knowledge to be able to take care of their best interests and also to help guide why certain decisions may not be achievable. Those some conversations may not be wise. And so it's about how do we, if the goal is to stay out of court, how do we prompt, that additional support? And so for the parent that's also up against the parent that may have some, serious mental health concerns, just on what does that look like? So when you've got that parent that's now up against the person that, evident that there's some mental health challenges, what does that look like for that parent?
um, obviously, so you're the parent who knows
So the other,
the other
so the other
parent.
parent, the parent that doesn't have mental health issues, but has, is up against the parent that has got some mental health
Mm,
challenges. How do you, as a
yeah.
lawyer, what's your view in supporting that process for that parent?
Sure. I guess it's. I feel sorry for the parent who has the mental health issues, but I equally feel sorry for the person that has to navigate, the other parent's mental health, especially where there's children. It can be harder. There's obviously a breakdown of trust due to the separation, and then you've got to co-parent with the parent who's got the mental health issues, and it can be harder because they've got to tailor their responses, their communication in a way that doesn't impact that parent that already has, vulnerabilities. So it's look what I say to clients is that look, I guess look at the bigger picture again. Look at uh, uh, if you know that your communication could hurt the other, the vulnerabilities of that parent. If you know your communication will hurt them, it will escalate the parental conflict, which will then impact the children. Then you've got to reassess how you're going to communicate with them. Don't push their buttons. Don't don't inflame the situation. Just and look, you can. There's lots of platforms now out there, to assist parents with their communication, applications and the like. Uh, Experts such as yourself, can help parents navigate and tailor their responses, sort of moderate it in a way that's not going to hurt the other parent. But there's no right or wrong answer there, Jeannie, as you know. All we can do is support and
Yeah.
gives information on how to deal with the situation.
Yeah, and I think sometimes the attitude of the parent that is up against that parent with mental health has the belief. We get sometimes this theme that there's the belief that they'll just take the greater time, or have the children live with them full time, but it doesn't discriminate. If the children are doing well with both parents, that will be encouraged. I guess it's about also the reality for parents that are in this position is understanding that the review of such an agreement, parenting agreement, may need to stay as a parenting agreement, not made into consensual orders, for the purpose of being able to, see how it travels through, see whether I mean, there's two and four for that argument, because one would say, no, it's best that we make at least consensual orders. But you can always review things. You can always have a look, in 2, 3 years' time to see what's actually happening. How's it all going? Are things now working well? Are the wheels turning properly? Do we need to tweak anything? Or has the situation escalated? Like, is it now, are there too many events going on, too many incidences that are causing further concern? So I think there's just, from what I just heard you say, it's all about, you're going to have to be a lot more flexible, a lot more adaptable, more so than the other parent, and adjust. It's a constant adjusting table, isn't it? It's
It
readjusting all
is.
the time, because mental health is a real thing. It's out there, and it's all about how do we try to prompt around that, and then how do we focus on the children, make sure that they're okay through that process. Taj,
It's hard, Jeannie. I
it
must
is
say
difficult,
it's hard given the
so difficult.
dynamic, and it's easy. And I think us humans, we just default to blame. We sort of look what he said to me, look what she said to me, and I get it, But the bigger picture is the children. The bigger picture is yourself. Um, if poison is thrown at you, you either drink it or you don't drink it. It's up to you. If someone's trying to provoke you, someone's trying to has said something that's offended you, take it just a deep breath, just assess. Try not to sleep on it. Try not to respond immediately. Um, uh, just know yourself. Just impulsivity is a problem. I think we want to avoid impulsivity, especially when communicating with the other parent, because you often
Get
say things
sticky,
and
get
yeah,
very sticky.
yeah,
Taj, a question, just to change, uh, just the direction. parents of that are concerned that maybe sexual um, interaction may be happening between, let's say, a parent and their children. How does that
Hmm.
get navigated where there's maybe matters that have been opened a few times, there's been investigations by soccer, but because the children, and I'm talking about children that are quite small, because it's very hard in these cases where one parent may have some significant concerns, but investigations have been left open to probability. So there's not an answer either way. How does that parent navigate those kinds of concerns where,
Hmm.
a child may be coming home still distressed, still not wanting to go? Like, on a legal perspective, what's the space there? What does it hold out for them?
Yeah, look, so very good question. And um, I think that there is a pathway, various risk assessments, etc. If the matter goes to court, but I think in these circumstances, it gets hard to sort of advise the client. Look, you've got to negotiate and mediate. I think, look, the answer is, court intervention is necessary. The other party needs to be assessed appropriately. Um, and then it's really based off the expert's opinion, their views, and whether um, uh, there can be any sort of safety measures put in place to ensure the child's protected, depending on the outcome of the risk assessment. So I'd be saying that you should be seeking a risk assessment at court as soon as possible. Um, Again, there are a number of variables, number of factors. The evidence is important as well, and that's part of my advice as well. What's the evidence? And I have to go down that pathway in order to advise the clients before they start investing money and going to court and the time and the energy. But the pathway is a risk assessment for the parent who's been alleged to have behaved in this manner. Um, plus a number of other variables as well. But that's the main sort of recourse for the parent who's alleging the abuse.
So the assessment for children under 5 is just quite difficult because once you've got,
Yeah.
if Socket have sort of closed the matter in that for that moment, they don't shut it down, but they may have just said, "Look, investigation done," and it's very difficult to find information. Um, and then if Child Protection have closed it down, what are the other means of risk assessments that are we looking at for these parents through the court process outside these two elements, which where the courts
It's
also
called
depend on?
called a psychosexual risk assessment. So there are psychiatrists, forensic psychiatrists, psychologists who will undertake that task, provide a report.
Yeah.
Yeah.
And
So
does a parent require that to be court ordered, or can, if both parents agree, is that something that can be volunteered by the parents if they both agree?
of course, anything by consent
Yeah,
can occur with the necessity of a court order. Yeah. Yeah, but it's hardly the case. Never
it
seen
is.
one where
Yeah,
where a
of
parent will
course.
agree for such an assessment unless they're compelled to do it by the court or advised by the lawyer
That's right.
within the court space. So yeah,
Yeah, yeah, of course. And you've just had a baby boy.
I have,
How's
I
that
have.
going?
It's tricky. I've got a 5-year-old and then now another baby boy, 5-year-old boy and then another boy. So. There is some positives and negatives of having a child one after the other, I think, but now I've got to relearn, redo everything again. So, sleepless nights, obviously, broken nights. I mean, my wife, all praise to her, she's taking on the lion's share of that duty. She understands that I've got to work, operate the business and on the side, I'm also assisting the 5-year-old, with the morning routine, lunches and the uniform and all the rest of it. So getting him to school on time. So It's a the schedule has just gone, to cinders. It's there's no schedule anymore. It's just do it. Is is what I say. There's no you can't. There's no schedule. The baby takes over the schedule. Children take over your schedule. All right, and but that's the beauty of life, I find. It's being spontaneous, just getting things done. You can spend 2 hours mapping out a plan. Okay, on this time I'll do this, and that time I'll do that, and then something just erupts, and all of a sudden there goes your schedule. You're gonna have a bit of a guideline there if you want. It's a bit like a court order. It's a guide there. It's a guide. It doesn't stop you and the other parent from deviating, doing what you want to do. It's there as a guide. But albeit I shouldn't say that flippantly because people do end up spending a lot of time, energy, and money on that order as opposed to just a daily routine schedule. But what I'm trying to say is that at the moment I've got no routine. When I get up depends on how tired I am the previous night, whether I have to get up 3 times in the night or 2 times depending on the baby. So yeah, it's a yeah, it's hectic. That's okay. That's life. That's life. You got to be active.
You
You have to.
do. And we see a lot of, we were talking about this earlier, where we see a lot of new families that end up tripping into our pathway because, we
Mm,
find out that they've just had, bubs and the pressure's on and it can put a lot of pressure on the couple.
yeah.
But we also see it at the very other end where, you know, the children have left the home. The mum and dad are finally looking at each other and trying to work out, where do they start to get to know each other again, or and other factors that may apply to that. What's your advice on that? Because right now you're just it's just busy station and it's all about, these two
Yeah.
little beings. And I guess for couples out there, especially families that are also in the same situation and trying to manage the chaos and being nice to each other at the same time because sleep deprivation is such a factor. What would be your takeaway for them,
Just it's such a change in dynamic, isn't it? The unprecedented change for many. And all I say is what's said and done, I mean, it can be hurtful, can be impactful, but just understand that it is a phase. Children, that initial month or two, the initial 6 months, it's very hard, very, very difficult to navigate that. But just remember that just to take it with a grain of salt. I mean, both me and my wife, we may have been short with each other, but what we know deep down, we care for each other. We know deep down that this is because of a new member who's completely vulnerable, dependent on you. You've got to just put aside that relationship you have with your wife for the sake of the baby, you will see the profits. You will see dividends later down the track. You just got to ride that storm, ride that phase out. I just silence. If someone says something, just they say in India, just keep silent, keep quiet, and many will be happy. If you retaliate, you shoot from the hip, always be remembered. Another layer of issue in your relationship. I'm giving relationship advice now, but this is the way I assess it. But just another layer of dispute later down the track. Just remember, what you've achieved with that person, and you could achieve a lot more with that person. But this and with this new member, who is completely dependent upon you at the moment, and will cause those sleepless nights. You will lose energy. You will be short, but just try and maintain the silence. It's okay. It's not the end of the world. We keep going. We keep going. Just
it'll pass.
we
It does
work
pass.
together. It does. It will pass,
Goes
and then
so
there'll be other
fast.
challenges. It goes fast as well. Just cherish it. Don't tarnish it with arguments, and you will regret it. You will. Just enjoy the good parts. And at the moment he's sleeping, not sleeping right. I have to change the formula. there was reflux, you can't poop because it's just these issues come. And I mean, we could be, oh my God, what's going on? We just deal with it in silence and just, let's try a few things here and there. Let's get some support in place. But there's ways to deal with problems. Deal with them in silence. If we're too hoo-ha, you're going to create 100 more problems. Not deal with the one that's before you. So yeah,
I have a saying with many of my parents, and I say, if a problem comes your way, it's not a your problem or my problem, it's an our problem. And especially when
Mm.
it comes to our children, it's an our problem. We've got a problem right now with Junior, or and if we have these communications, even if it's with the other parent that you're no longer with, it's no longer creating that tone as if it's your fault. It's about focusing where the problem's coming from and approaching it that you two are a dynamic. And I talk a lot about this, that you need to present that the kids are not entitled to know that you don't like each other. And what they're entitled to know is that both their parents have got their back and they're a team together. And with that approach, it does take away all those layers as you just described them, and it helps to zip up all the crap you do want to say, but you won't. And you just approach it in such a good way, mature way as well. Good advice. Congratulations to both of you. He's just
Thank you, Jean.
beautiful, divine. Cannot wait for the
Thank
next
you.
party that I've invited myself to
I thought you
again.
were going to say the next child. I'm like, no, we're done.
No,
Two,
no.
two is enough.
All right. Look, thank you, Kaj, for today. I think it's been really helpful. And thanks for everyone that's popped in today and had a listen. And White Table Discussion podcast. You'll see advert when the next one is on. And thanks heaps, Kaj, for all the work you're doing with our
Thank you,
parents as
Jean. Thank
well.
you for inviting
Amazing.
me. Appreciate it.
Easy,
It's
as
great.
always a pleasure to chat with you. All right, guys, we'll see you soon. Thank you. If you or someone you know could do with our help, please book that free consultation at Parenting Together Apart for Parents Not Together. Remember, you don't need to do this alone. We'll look forward to meeting you soon.